Testing, testing, 1, 2, 3.
Good morning, everyone.
Morning, Judge
Hello.
Rovner. Good morning, everybody.
Morning.
Good morning. All right, we will begin on this November 1st. And the first case of the day is appeal number 21-3303, TS versus the County of Cook. And good morning, Mr. Henready. Good morning.
Good morning, Your Honor. May it please the court. There are two discrete issues before you here today. First is whether the district court erred in finding that the Illinois officer suit exception precludes defendant Leonard Dixon's sovereign immunity defense on the sole remaining state law tort claim. The second issue is whether the state breach of fiduciary duty claim can be maintained against Dixon, the superintendent of the Cook County Juvenile Temporary Detention Center. Plaintiff's claims stem from Dixon's decision to allow filming of the television series Empire within the walls of the detention center. Plaintiffs initially claimed that due to the filming, they were confined to their cells for days and that they were not provided with medical care. Discovery proved these claims false, and the district court dismissed the majority of defendants and claims, including properly granting Dixon qualified immunity for the Section 1983 claims. As this court well knows, hundreds of conditions of confinement claims are brought under 1983 each year against correctional centers in Illinois. This is the standard and appropriate method for bringing such claims, and all of the claims have been dismissed from this case. All that remains is a breach of fiduciary duty claim, a state theory of liability normally alleged when parties have a corporate or financial relationship. Turning first to whether the officer suit exception applies to bar Dixon's sovereign immunity defense, it clearly does not. The exception holds that the state defendants are not entitled to sovereign immunity, where plaintiffs seek prospective injunctive relief if the state official violated statutory or constitutional law. Since the plaintiffs in this case are only seeking money damages and not injunctive relief, the exception does not apply, and Dixon is entitled to sovereign immunity.
Let me just ask you, I'm sorry, you were going to say finally, go ahead.
Oh, no, Your Honor, go ahead.
Oh, I wish you'd finish your thought. I'm sorry, I interrupted.
I was just going to say, in finding to the contrary, the district court relied on this court's holding in Murphy v. Smith, which in turn interpreted an earlier Illinois Supreme Court case that invoked the officer suit exception for purposes of prospective injunctive relief, but did not address monetary damages for alleged past wrongs.
What I wanted to ask you is this. Has any Illinois court held that the chief judge or the superintendent of the Juvenile Temporary Detention Center cannot be considered a state employee? Has that ever occurred?
Not that I'm aware of, Your Honor, no.
And there is this Mullins case, Mr. Henready, which indicates it's a district court level that indicates Mr. Dixon is a state level employee.
That's correct.
Was it within Mr. Dixon's authority to allow outside groups or organizations to use the juvenile facility?
Yes, Your Honor. That is something that they have done in other circumstances, and that is within his authority to control.
I have the very same question because I too wanted to ask if, as superintendent of the center, Dixon, I take it, was responsible for approving any outside groups that sought to present programs or in any way have access to the center, or was there another employment position at the detention center with that particular authority?
Ultimately, it would be the office of the chief judge or Mr. Dixon who would make that decision.
Mr. Henready, can I take you back to the question that Judge Brennan was asking and Judge Rovner's question was getting at about Mr. Dixon and his status as a state official? I'm aware of the Mullins case. What is the legal standard under Illinois law for measuring or assessing whether someone is a state employee or state official for purposes of the sovereign immunity determination versus a county official? And the reason I'm asking that question is I'm trying to understand what is the limiting principle here?
It's the right to control, Your Honor. There's a case called Darner v. Colby. The Office of the Chief Judge has control over the JTDC, operational control, pursuant to the County Shelter and Detention Home Act.
Right. So and I know that he has appointed Mr. Dixon, or he did appoint Mr. Dixon superintendent, right? And
That's
so
correct.
the theory would have to be that the control then is transferred to Dixon, and it's transferred to Dixon under the cloak of this state authority that it started with, right?
That's correct, Your Honor.
Okay. So would all correctional officers at the detention center therefore also be state employees for purposes of sovereign immunity, or would Superintendent Dixon's chief deputy be a state official?
I would say yes, Your Honor, although I don't believe there's been any cases on that direct point.
Okay, and you're measuring it when you talk about control is vested in the chief judge, correct?
Correct.
Okay, and then it's conferred upon the superintendent, and Mullins concludes that's enough, at least for the superintendent.
That's correct.
Okay, and is Illinois law unsettled on where it flows from there?
No, Your Honor, because I would say, while it's never directly addressed, as far as I know, correctional officers at the detention center, it would certainly flow that way for the state police and people of that nature.
And tell me more about the state police. How does it work with them?
The state police are all considered state employees and entitled to sovereign immunity under the proper circumstances. That's the Healy, not Healy, but Curry v. Lau and a couple of the other cases at issue here address sovereign immunity for state police officers.
Okay, and it matters not one whit that Mr. Dixon is a county employee.
Well, I'd argue he's not a county employee. The county, the county does do some does pay part of the salary and the budget, has certain control, but in a lot of cases, and I can't get into all of them right now, but in a lot of cases, the state will reimburse. It does.
What part of the salary don't they pay?
I believe his salary is reimbursed by the state.
Is that in the record?
I don't have it at my fingertips, Your Honor, but I believe that it is somewhere in the record, or it might just be statutory.
Now, it's true, is it not, that the parties stipulated that Dixon, as the superintendent of the facility, was the chief judge's final decision maker with respect to the Empire filming, right?
That's correct, Your Honor.
So one would say, I would think you would argue, that Dixon was exercising the authority provided to the chief judge in his capacity as the state, and therefore acting as a state employee.
That's correct, Your Honor. And regardless of anyone else working there, that is correct. That in this case, that has been stipulated to. If I may turn briefly to sovereign immunity in this case, the plaintiffs have sort of pivoted here. They did not argue below that Mr. Dixon did not meet the elements of sovereign immunity under Illinois law, and instead relied entirely on the officer suit exception. So I believe their current argument that he doesn't meet all the elements has been waived, but regardless, he does meet all of the elements. They are, very briefly, that the state employee did not act beyond the scope of his authority. 2, the alleged duty was not owed to the public generally, independent of state employment. And 3, the complaint of actions involved matters ordinarily within the employee's normal and official functions. As to the first element, Dixon did not act beyond the scope of his authority. As already discussed, it's not disputed that he had the authority to approve and facilitate filming within the walls of the detention center. and that even alleged wrongful acts are protected by sovereign immunity as long as they don't exceed the scope of that authority. Second, Dixon did not owe a duty to the general public independent of his employment. Dixon would have no duty whatsoever with respect to either the detention center or plaintiffs, but for his state employment. And then third, Dixon's administrative decisions regarding the use of space and resources at the detention center, as well as housing, scheduling, and activities, were within the normal and official function as superintendent. And then finally, for purposes of sovereign immunity in Illinois, in addition to the Healy factors, the courts must consider whether a judgment for the plaintiffs would operate to control the actions of the state or subject it to liability. Here, the judgment in favor of the plaintiff would go directly to how Dixon, in his role as superintendent, uses the resources of the detention center and his oversight of scheduling activities and housing. Plaintiffs have sort of raised this idea that sovereign immunity may not apply because they've named Dixon in his individual capacity instead of his official capacity, but under Illinois law, actions are characterized as official capacity or against the state based on the issue involved and the relief sought, and cannot be circumvented simply by naming the defendant in his individual capacity. Plaintiffs themselves appear to concede this at pages 27 and 28 of their brief, where they note that the question at hand is whether the fiduciary duty is owed by the state of Illinois to the minors entrusted to its care. And then very briefly, even if sovereign immunity did not apply, plaintiff's breach of fiduciary duty claim does fail as a matter of law. In order to maintain a state fiduciary duty claim, plaintiffs must establish that Dixon owed them a fiduciary duty, which in Illinois law means a special circumstance or special circumstances of the parties' relationship. This generally applies to financial and business relationships. It's never been found to apply between a correctional officer and a detainee ever, not in Illinois or anywhere else in the country. And plaintiffs are effectively asking this court to endorse a brand new theory of liability based on their reading of the Parks case, which was overturned by the Illinois Supreme Court. In Parks, the allegations against the defendant were that the plaintiff removed a minor from her family for the purposes of sexually, physically, and psychologically abusing her. The Illinois courts found that this violated every moral, ethical, and legal duty it could name, and did refer to the defendant at one point as her guardian. But plaintiff's argument that a constructive guardianship thus became the law of Illinois is unsupported, as the case was reversed on other grounds by the Illinois Supreme Court. The court did not discuss, let alone endorse, the findings of constructive guardianship, and neither has any Illinois court since. So
why does the Illinois Supreme Court's decision on the statute of limitations ground mean that the intermediate appellate court's analysis of the guardian-ward relationship was flawed or does not reflect Illinois law?
It doesn't necessarily, Your Honor, or even usually, but I don't think Parks created a new fiduciary duty in any circumstances, because generally guardianship is statutory and not constructive, and none of the elements of the statutes were met in that case or this case. But even if Parks' decision was right on those facts, they would not necessarily be extended to a correctional administrator, because there's no guardian-ward relationship in this case anyway, and no fiduciary duty. So I will, I've got a little time left I'd like to reserve for a while.
Of course. Good morning, Ms. Hoffman. Oh, you're muted.
I knew I would do that. I always do that. I apologize, Your Honor. May it please the court, and good morning to you as well. Plaintiffs are children held pre-trial at JTDC who brought this suit to vindicate their rights after Warden Dixon placed them in punitive lockdown conditions, all so that he could film a television show and meet celebrities. In denying summary judgment on plaintiffs' state law claims, the lower court relied on a general principle of Illinois jurisprudence, which courts have applied in damages suits since 1937. This general principle is that state sovereign immunity affords no protection when it is alleged that a state official has acted in violation of constitutional law or in excess of his authority. This is nothing more than the definition of an ultra vires action. In so holding, the lower court relied on the Illinois Supreme Court case Fritz versus Johnston, Healy versus Vopel, and indeed this court's own holding in Murphy versus Smith.
Forgive me, but if we determine that under the Healy test, the claim here is actually against the state, would you then concede that under Parma, sovereign immunity would apply, given that damages are sought rather than prospective injunctive relief?
That is correct, Your Honor, but the Healy test has to be employed, and then once the Healy test, if this court were to find that defendant Dixon meets his burden because it is a conjunctive test, all three aspects of the test need to be met, then it is in fact a state case where the state is the true party at interest. And then the Illinois Court of Claims would have to hear this case. But Dixon has not met all three prongs of the test. For example,
Just a minute. Under the Healy test, isn't the duty that Dixon has to these plaintiffs related solely to his employment position, in that Dixon has no relationship whatsoever with respect to the plaintiffs other than through his position?
Respectfully, no, Your Honor, that is not quite right. So under prong 2, courts look to whether there is a general duty that exists within Illinois common law. The duty that is alleged to have been breached does attach to the general public, not solely in state employment context. The duty here is the duty that any adult would owe to any child in his care. If Dixon was not in a juvenile detention setting as warden, and he was instead in another situation where he had control over these kids, then he will be breaching a general duty. If, by contrast, this was a duty that only juvenile detention wardens had to juvenile detainees, then that duty would be one that would be satisfied under prong 2. But
help me with this then. How would a fiduciary duty to prevent harm to those detained even work in a custodial setting? Isn't the confinement itself harmful? Doesn't a superintendent have to protect a public interest in addition to considering the well-being of any individual who's detained?
Yes, Your Honor. So this is a pre-trial detention, so it is meant to be rehabilitative. The children are not allowed to be harmed in some sort of penological way at all. And so the test would be whether or not he is pursuing his own personal interests in placing children in punitive lockdown conditions, as opposed to a legitimate government purpose. And that is precisely what the lower court held. Judge Pallmeyer held that there exists a genuine dispute of material fact as to whether Dixon was pursuing his own personal interests in placing them in lockdown conditions just to bring his wife to the facility to meet celebrities and take photographs with them. If he was doing it for some sort of legitimate purpose, such as a COVID lockdown or a safety concern, that would be within a legitimate government purpose, within the public interest, as Your Honor cites. But this is certainly...
I am having some problem with your argument because the way I believe I see it, but I can always be convinced, God knows. When you apply that second factor, the duty alleged was not one owed to the public generally, independent of the fact of state employment. You argue that he has a fiduciary duty to the plaintiffs, but any such duty, it seems to me, would have to stem from the relationship created by them, between them, I should say, I guess, by virtue of his position as superintendent. He doesn't have a relationship with the plaintiffs other than as superintendent, so no duty is owed to them in his role
Yeah. Oh, sorry, Your Honor.
Or it seems to me by virtue of circumstances that are outside of his position. So it seems to me that the second factor is met here.
Well, Your Honor, I just want to note as a preliminary point that Dixon has to meet all three prongs. He obviously cannot meet prong 3.
Why can't he meet the third factor?
Is
Are
clearly
we saying that the complaint actions don't involve matters that are ordinarily within his normal and official functions?
Yes, Your Honor. Indeed, as the court, rather, my friend on the other side mentions on page 12 of his reply brief, this is not within his typical job functions to place children in lockdown conditions, not for a legitimate government purpose, but instead to simply meet celebrities. If it's true what plaintiffs are alleging and indeed have shown at the summary judgment stage, he has placed them in penological purposes, not for a legitimate government purpose, which is certainly outside one's normal and official functions. It is not within his normal and official functions to place them in lockdown conditions so that he could receive a signed director's chair, invite his wife to the facility to meet a bunch of celebrities and take photographs with them.
We've heard that now 3 times. Is there some allegation that in entering into the contracts here that he exercised authority that wasn't granted to him?
Yes, Your Honor. So just because he has, as part of his job functions, the ability to make contracts on behalf of the state does not mean that he can make contracts on behalf of himself for his own personal interests. And that is precisely what has been alleged here and shown at the summary judgment stage. So there's a distinction between his power and his authority. His authority has legal limits, that of the Constitution and Illinois common law. And plaintiffs have alleged and shown on summary judgment that he exceeded his authority by exceeding those lawful limits, which prohibit state officials from abusing their power for personal gain.
Ms. Popkin, can I get the benefit of your perspective on a different question?
Yes, Your Honor.
And it's this. The way I understand the district court's ruling on the immunity issue is that it's a trial issue, and it's an issue that's going to be presented to the jury as to, perhaps in addition to the state fiduciary duty breach or the alleged breach, the jury is going to consider the merits of the 14th Amendment claim under the U.S. Constitution as to DeShaney, because that's pertinent to whether Mr. Dixon violated the U.S. Constitution, and that in turn is relevant to the state sovereign immunity kind of threshold gating question. Is that a fair description, you think, of what happened in the district court, whether right or wrong?
Yes, I believe that is the correct interpretation of its holding.
Okay, so what I find is odd about that is that state sovereign immunity, or the availability or lack thereof, is going to turn on the jury's resolution of a dismissed federal claim. In other words, there's no circumstance in light of the qualified immunity holding under which the plaintiffs can receive damages for a violation of the U.S. Constitution. That world no longer exists because of the dismissal of that claim. Why, therefore, would you send to trial that claim for purposes of a state law immunity analysis? Why wouldn't the state law immunity analysis, in other words, only turn on those claims that remain in the litigation? So here it would be the state law claim.
Yes, Your Honor. It is the reason why is because this is a jurisdictional question. It doesn't ask the underlying merits of one's claim. It only asks the simple question of who is this plaintiff trying to sue? So that's why if you look to the Healy test, it all involves allegations.
No. I don't think that's right. I think that by the terms of the district court's opinion, the substance of the 14th Amendment DeShaney claim would be put to the jury. And the jury would return a verdict on whether there was or was not a violation of the DeShaney standard, correct?
That is what the lower court held. I personally, would not agree with Judge Pallmeyer's decision to have the substance of the constitutional claims be at issue. State sovereign immunity, according to every single Illinois court that has ever employed the three-part Healy test, has only looked to allegations because it is a jurisdictional question. It is only asking who the plaintiff is trying to sue. In fact, even on summary judgment, the Illinois Supreme Court...
Do you know of any case in state law that has ever hinged the viability of the state immunity question on the resolution of the merits of a dismissed claim?
No, Your Honor, but this court need not do so, and neither does the lower court need to do so, because there are intentional tortious claims that remain live in this case that are predicated on the very same underlying acts of the constitutional claims.
So is that to say you don't agree with the district court's analysis either?
In terms of the
point that I'm asking you about, on the DeShaney U.S. constitutional analysis.
No, Your Honor, I think that a court can simply look to the existence of illegal actions that are outside the scope of one's authority that have been alleged. That's prong one of the Healy test. Here, he does not meet it. Even if there were no constitutional claims that have ever been in this case, the intentional tortious claims are outside the scope of Dixon's authority and necessarily preclude him from meeting prong one.
Okay,
that said,
now I think that is within the scope of what the district court decided, correct? In other words, that the trial that was ordered, the trial would consider the merits of the state law fiduciary duty claim, correct?
That is correct, Your Honor.
Okay, and if a verdict were returned in your client's favor, that would bear favorably upon your position that the defendant is not entitled to state immunity.
That is correct, Your Honor.
And that has nothing at all to do with the U.S. Constitution.
Yes, Your Honor.
Okay.
But I guess if I may return to just pivoting away from the three-part Healy test, what Judge Pallmeyer certified, the question that she certified was whether Parmar has any bearing on this court's holding in Murphy versus Smith, and it does not. In fact, defendants concede on reply at page 16 that individuals can be sued for damages on state tort claims. So I would ask the court to reaffirm its holding in Murphy versus Smith, because Parmar, being an official capacity suit that merely holds that in official capacity cases a litigant cannot sue for damages because it is tantamount to a lawsuit against the state, that has no bearing on Murphy, which correctly relied on this three-part test in Healy.
The Murphy decision doesn't disaggregate between personal capacity suits and official capacity suits, correct? That failure to acknowledge that difference could be an issue with Murphy, correct?
No, Your Honor. I don't think that Murphy needed to opine on the official capacity claims, because this court correctly relied, pursuant to the Erie Doctrine, on the holding in Healy versus Vopel, which establishes the three-part test, which must be employed in personal capacity damages suits when a state officer brings the state sovereign immunity affirmative defense forward. It's the test that courts must employ, even and still do employ even to this day, whenever state sovereign immunity is raised as an affirmative defense. Murphy was quite right there, and Parmar does not disturb its analysis whatsoever.
Well, there are two lines of cases that Murphy is relying on, right? And at certain instances, there's a citation to the second line of cases when perhaps it's resolving an issue on the first line. Is that fair?
Yes, that's fair. I think that to your honor's point, Murphy does rely on Leaderoo, which is an official capacity case that employs the officer suit exception. It only relies on it for a general principle of law, that of the Ultra Vires Act, that an officer who is alleged to have violated the Constitution or committed some other action outside the scope of his authority, that he cannot avail himself of state sovereign immunity. That is a general principle of law that is applied in damages cases and injunctive relief, or rather official capacity cases alike. And so it's two very distinct areas of law. And Murphy does point to this general principle that is relied on in both situations. But I think that Murphy was correct in that it applied the three-part test in Healy, which is the only test that governs this case, and the test which Dixon has failed to meet. In fact, he waived arguments as to prongs 2 and 3 below. His entire summary judgment brief is completely silent as to prongs 2 and 3. And there is no way that he has met prong 3, which is that he was acting within his normal and official functions, given the allegations that he was placing children in punitive lockdown conditions so that he could meet Chris Rock with his wife and receive a signed director's chair. I mean, there is just no argument to the contrary that he was within his normal and official functions when doing so. So missing prong 3 alone is enough to preclude him from availing himself of state sovereign immunity. And one other point as to the constitutional allegations, they were dismissed only on the basis of whether or not they were clearly established at the time, but that has no bearing on a state sovereign immunity analysis. In fact, the lower court explicitly held that there exists a genuine dispute as to whether he violated their 14th Amendment rights. So that would constitute a wrongful act that would preclude Dixon from satisfying prong 1 as well.
Judge Brennan, Judge Scudder, do you have any other questions for Ms. Popkin?
I do not.
I do not.
All right. Thank you, Ms. Popkin, very much.
Thank you.
And Mr. Henready, you have less than 2 minutes, but we did give Ms. Popkin the extra time, so let's give you 4 minutes, please.
Thank you, Judge. Very briefly in rebuttal, I believe it was Judge Scudder hit on the notion about the DeShaney claims being put to the jury. And I think that's important because if the DeShaney claims, the way that the district court styled that was that the DeShaney claims would have to go to the jury to determine whether or not there'd been a violation of constitutional law. And if there were, then sovereign immunity wouldn't apply. And that's why this circles back to the officer suit exception, because under the officer suit exception, which Illinois says is also the prospective injunctive relief exception, those allegations don't matter for purposes of sovereign immunity. They can, if they are made in a case where they are seeking prospective injunctive relief, that bars sovereign immunity. Otherwise, sovereign immunity is available. And also, Ms. Popkin mentioned that there were still allegations of torts claims that would prevent Mr. Dixon from meeting the first elements of the Healy test. But the Illinois case law is very clear that you can't, the claim for tort does not take someone outside of sovereign immunity, because if it did, people would just allege a tort every single time. It assumes a wrongdoing may exist and that sovereign immunity would still apply.
As opposed to what? An alleged statutory violation?
As opposed to a statutory violation or some other violation, but yeah, I believe that's correct. But simply alleging that someone did something wrong, alleged wrongdoing, doesn't take it outside of the realm of sovereign immunity as long as they're within their duty and they're within the scope of their duty. With that, I would just ask that for the reasons addressed here today and those set forth in our brief and reply, we'd ask this court to reverse the district court's partial denial of summary judgment and specifically find that 1, the Illinois officer suit exception is inapplicable to this case, and thus Superintendent Dixon is entitled to sovereign immunity on the state breach of fiduciary duty claim, and 2, that Superintendent Dixon does not owe plaintiffs a fiduciary duty under Illinois law. Thank you.
Well, thanks to both parties for that spirited discussion, and the case will be taken under advisement. Thank you very much.
Thank you.
Okay.
Thank you.
Thank you. The second case of the day is 213021. It is Sing Thong versus Bowen and Baldwin, but it will be taken on the briefs. There will not be oral argument at the request of the parties. I might note at this point that after the argument in case number 3, we're going to take a 10-minute break so that you in the courtroom know that. All right. Case number 3 is 211482 and 211672. It's United States versus Jones and Schimenti. And Mr. Van Zant.
Good morning, Your Honor. May it please the court.
Good morning.
I was reviewing the briefs yesterday, preparing for oral argument, and one thing that stuck out at me was a quote that this court said in United States versus Barda. And that was the point of entrapment cases such as these is that the government is supposed to catch criminals, not create them. And that's exactly the issue that we've got here in this case with Mr. Jones and Mr. Schimenti. The government...
I'd like to start you right out, because what evidence is there that the undercover agents went beyond merely presenting criminal opportunities over the course of the 2+ years and instead engaged in efforts to persuade or coerce? In other words, when Jones declined the criminal opportunities early on, was there any evidence of any adverse repercussions from the undercover agents?
If I'm understanding the question correctly, Your Honor, did the agents engage in some sort of retributions or some sort of escalation? Is that the question?
Probably, yes. Yes.
I think that's a good way of considering it. Where this started out was actually very minor. This was simply an internet social media operation observing what Mr. Jones was saying. And you'll note that even in February 2015, he had stopped posting online, and agents reached out to him and asked him to come back, keep doing what you were doing before. The next scenario that they thought up was this scenario at the Zion Police Department. And they simply were attempting to get Mr. Jones to introduce one agent to another. That didn't work out. So they went on to the next opportunity, which was trying to get Mr. Jones to help someone else travel to Syria, in addition to himself. That didn't work out. And over 2.5 years, the scenarios that the agents were employing escalated incrementally over time. And I think that's the exact point of this entire case, is it took 2.5 years before Mr. Jones did anything criminal. That's the sort of analysis that this court's talked about in cases such as Barda, that the U.S. Supreme Court talked about in Jacobson, is if Mr. Jones was actually predisposed towards this sort of thing, if he was predisposed towards committing a crime, it shouldn't take 2.5 years to talk him into it.
Isn't part of the problem, Mr. Van Zant, the testimony in front of the grand jury? It just seemed so uncommon that here's this template that even prior to indictment, here's Mr. Jones speaking under oath with regard to a lot of these factors or criteria that courts might look to on this concept of predisposition.
No, and that's absolutely right, Your Honor. I think that the entire case was laid out very early on in front of the grand jury. But the fact that Mr. Jones was thinking about these issues is a very different question from whether or not he was ready, willing, and able to take criminal action to support the Islamic State, as opposed to exercising in general First Amendment thought processes. looking into these things, being a good Muslim, learning about his religion. That's the big difference here, is we don't have a scenario where Mr. Jones and Mr. Schimenti had a plan. They had an intent to commit some sort of terrorist act. All they were looking for was the ability to do it. That's not the situation here. If that was true, then the government would have easily been able to set up one of these scenarios within months of contact. And that's the situation that happened in cases such as, Evans, Barta, things like that. And even in the name is
Mayfield?
escaping me.
Mayfield?
Yes, Mayfield, thank you. Yeah. So that's really the problem. And I'm sorry, Judge Scudder, did you have a question?
Well, go ahead and finish your thought.
So that's really
I do,
the problem
but
here.
go
and
ahead.
that's what's bothered me about this case the entire time is in most entrapment cases where this defense is found to not be viable, it's a situation where someone jumps at the opportunity. Some of the trap house cases are like this. Some of the scenarios where an individual will be approached and within maybe 1, 2, 3 overtures, they're engaged in a criminal scheme. But here we're talking about a period of 2.5 years of constant pressure from constant government agents before anything happens. And what that anything turns out to be is a ride to the airport and a couple of old phones, which is far different than what the agents originally thought may even happen here.
What the grand jury testimony troubles me for your position, and what stands out in it is your client seems to me to quite directly have said that yes, I knew that those cell phones, the plans around the cell phones were for them to be used as bombs to kill people, and I hope that's what they're used for. That way, that can certainly bear, and that was in front of the jury, right? That can certainly bear upon the jury's assessment of both dimensions of the entrapment inquiry, can it not?
To an extent, Your Honor. I think the problem here is when we look at the timeline, this issue of the cell phones didn't come into play until early 2017. Mr. Jones was approached by the government years before. So what he was thinking at the time of, when he gave over these cell phones, that's not necessarily relevant to whether or not the government...
Your point is that's all infected by the taint of the entrapment.
That's precisely it, Your Honor. And one of the things that jumps out in my mind is what this court said in United States versus Evans, which was if he was indeed entrapped, it's irrelevant that the entrapment was so effective as to make him not only a willing but eager participant. And that's the problem. So by the time that we're talking about the cell phones, we're so far down the rabbit hole of the government scheme that it doesn't matter. So that's why it's very important to look at what was his predisposition prior to the government's interactions with him. And the first government interaction was probably as far back as February 2015.
So when you look at that, and you've done a very fine job laying this out, that at that point in time, your client had a pretty meaningful presence in the social media world and was active in discussions, in those circles. But you argue that's First Amendment protected, right? And has, I suppose to some extent that it is, but I took your brief to go further than that you were saying the speech is protected and it is precluded at this relevant point in time, the very, very, very early phases of this, before the introduction at the police department. And we cannot consider that because it's protected for purposes of assessing predisposition. And that's what I took your argument to be. Now, my question is, has any court that you know of endorsed that view?
Not in that formulation, Your Honor, and I definitely understand where you're coming from. When I was rereading this, I think I could have made the point better.
Yeah, so if I overstated it, what's the more narrow articulation of it?
So I think that Jacobson is what really tells us the answer here, and that is the inclination to do what is lawful cannot be used as predisposition, as evidence of predisposition to do what's unlawful. So, for example, in Jacobson, if you recall, the defendant had ordered child pornography and expressed an interest in it prior to it becoming illegal, and then the government was attempting to use that as evidence that he was predisposed to therefore do it when it was illegal. So I think that I probably overstated a little bit, but what I'm trying to say is that when we're looking at First Amendment protected activity, however reprehensible, that's legal. So it is not something that we can say is useful predisposition because it's lawful.
Well, hold on. His viewpoint, his sympathy with ISIS, and the views that he holds about Syria and the Assad regime can be First Amendment protected, right?
Correct.
Okay. So, but why can't they also inform the elements of the entrapment defense?
I think that goes back to what Jacobson dealt with, Your Honor. So while we're talking about First Amendment here, that was sort of an underlying discussion in Jacobson. It's not as explicit as it probably should be.
That's fair.
But,
right.
but that's the idea, is if we've got something that he's doing that's completely lawful, the point of the entrapment inducement predisposition inquiry is he inclined to break the law to further his interest in this? So is there evidence before the government became involved that Mr. Jones was going to break the law to further his interest in ISIS? And I don't know of any. Now, we've certainly got stuff after the government became involved, but then that gets us back to the whole inducement question. And I think one of the most interesting parts about this is that while we talk about inducement and predisposition separately, the case law is fairly clear that the inducement is largely useful for determining predisposition. The less inducement there is, the more likely someone's predisposed. The more inducement there is, the less likely. And here we have 2 years, roughly, of inducement by the government before anything illegal happens. I've got about 5 minutes left. If there's no other questions, I'd like to reserve. Thank you.
Absolutely. Okay. Good morning, Mr. Fullerton.
Good morning, Your Honor. May it please the court. There was ample evidence here to show that Joseph Jones was predisposed to commit the crime for which he was convicted. And that evidence showed that Jones was predisposed to be supportive of the Islamic State, be sharing propaganda of the Islamic State, and this is before any contact with the government. He was active on social media, as Your Honor pointed out. He was actively...
Yeah, but can I stop you? Because let's focus solely, okay, on this time period before the undercover agents interacted with Jones, just as you're doing. But could you be very specific? In other words, what specific evidence demonstrates that at that point, okay, he's ready and willing to engage in criminal conduct in support of ISIS, as opposed to merely speaking in support of the goals of ISIS?
At that point, Your Honor, I don't think the evidence showed that. The evidence showed his broad support for the goals of ISIS, his sharing of propaganda. It warranted further investigation and thus the introduction of the undercover Omar at the Zion police station. Very quickly after Omar was introduced to Mr. Jones, Omar asked Jones, have you ever thought of going over to the Middle East and joining the caliphate? And Jones said, every day and every night he thought about that. Now, at that point, he's indicated not only a support of ISIS, propagandizing for ISIS, but also indicating he wants to join ISIS. Again, this was not a product of convincing Jones to say that. Jones volunteered that to Omar. At that point, then, the FBI introduced Bilal, because Jones had expressed a desire to go over, to travel abroad, and he had expressed a desire to meet additional people that he could learn with and build with. And at the end of 2015, there was a meeting with Omar, Bilal, Jones, and Schimenti, and nothing came of it. Shortly after, Schimenti got scared, he backed out. At the end of the meeting, Jones said, well, let's stay in touch, okay? And shortly after that, Omar told Jones that he was going to travel abroad, and the scenario was known to Jones that apparently Omar had traveled abroad, okay? And this was early in 2016, within just a few months after Omar had met Jones. Then in 2016, there was really nothing happened with Jones for months. There was no multiple efforts to persuade him to do anything, no approaches to Jones by Omar, who was supposedly abroad in Syria. There was very little that happened with regard to Jones in 2016. Now, they were keeping an eye on Jones, and Jones began to be active again on social media in the summer of 2016. And
when you say again, are you saying that there was this long lapse? What is it you're saying?
I believe there had been a lapse in 2016. Jones had deleted, I think, his social media accounts, his Google Plus account. But in 2016, in the summer of 2016, Jones met an individual online who was referred to at trial as Omar number 2. And when Omar number 2, who was not part of the undercover operation, but he was working with the FBI, when Omar number 2 expressed to Jones that he, Omar 2, was dissatisfied with living in the United States, Jones volunteered to him almost immediately that he knew a man who could help Omar number 2 travel abroad and join the caliphate. That referring back to Bilal, who by this time Jones had thought had helped Omar number 1 travel earlier that year. Okay? So Jones meets Omar 2 somewhat randomly online and introduces him, brings up the idea and volunteers the help of his friend, his acquaintance, Bilal. Okay? Going forward then, Omar number 2, the scenario is that Omar number 2 travels abroad with the help of Bilal. And that's where it was left with Jones by the end of 2016. He had not been asked to do anything. They had not attempted to persuade him to do anything. There had certainly not been multiple attempts to get him to do something. They had not met with any resistance from him because they hadn't asked him to do anything. But then in the spring of 2017, when Muhammad was working with Mr. Schimenti, the co-defendant, Muhammad devised a scenario where he was going to travel abroad to join his brother. Now, Muhammad talked about it with Schimenti for quite a long time, and then at some point Schimenti said to Muhammad, this is towards the middle of February, end of February 2017, Schimenti told Muhammad, my friend Jones wants to meet you. And then Jones, so this is within 2 months of the arrest in early April 2017, Jones meets Muhammad, who he thinks is going to be traveling abroad to join ISIS. And Jones offers to introduce Muhammad to Bilal. And when Jones learns that Muhammad's brother, the others overseas, need cell phones, Jones volunteers to give cell phones to Muhammad, and does. He gives him 2 cell phones and recruits his girlfriend to provide a third. Now, Muhammad had not asked Jones or Schimenti to provide cell phones. He had not asked Jones or Schimenti to give him the name of somebody who could help him travel abroad. This was volunteered by Jones. All of this, and so Jones's predisposition is shown in this way.
Unlike what my opponent is saying, this was not a 2.5-year effort to wear down his will or to work on him to get him to commit a crime. This was a somewhat brief approach in the fall and winter of 2015, and then really the events surrounding the cell phones was in February and March of 2017, with a large gap in between where Jones had volunteered to Omar number 2 the name of Bilal, the person who could help him travel overseas. So this was not a case of extensive efforts at persuasion or inducement, and you know, the main thing is this was sufficient evidence on which a reasonable jury could find that Jones was predisposed to commit the offense and that he had not been induced to do so.
Mr. Fullerton, can I ask you a question on the predisposition? And it's kind of a legal question.
Certainly.
But it involves the facts, of course, is the measurement. So measurement period. So if you go back to what Judge Rovner was asking you about the investigation beginning with the encounter at the police department, and before that there was FBI monitoring, right? Monitoring of his activity on the internet, physical surveillance, and the like. In your view, do we measure whether he was predisposed solely in the period before the first encounter at the police department? Or can the measurement bleed into what we might think of as the more active investigative period after the introduction of the undercover at the police department? What's the answer to that legally?
I think the case law is pretty clear, Mayfield in particular, that both periods are to be considered. In some cases, for example, there may not be a pre-investigatory period where you have evidence of a person's disposition, but in fact you're just confronted with their reaction to an opportunity that might be created by law enforcement. And so I think the predisposition...
So those early interactions with, is it Omar 1?
Omar 1.
So the early interactions with Omar 1 are relevant, and Mr. Jones's reaction and his statements, etc., in those early interactions with Omar 1 are relevant to assessing predisposition.
Yes, and they're relevant both pro and against his predisposition, and they were argued that way. I mean, Jones had stated that he thought day and night about traveling overseas, but when introduced to Bilal, Jones didn't in fact travel overseas.
Can I ask you a question on a different topic, just in the interest of time? Sure. And that is on the Rule 33 new trial motion. If you could go back and do it all over again, would you make the disclosure about the contemplated payment?
I don't know that I would, Your Honor. I'm not sure what I would have disclosed. That a government witness had thought about, desired to reward a government witness. And that nothing had been decided upon, no promises had been made, no expectations created.
What about that $5,600 though? The $16,000 seems to be accounted for, and we've got documents on the record as to what the breakdown was, but some of that is unaccounted for, the $5,600 of the $16,000.
It was unaccounted for, Your Honor, it was all accounted for. The testimony was that it was all expense related, but there was an entry on the FBI statement of expenses or whatever statement that placed it into a column where it appeared to be of a similar nature to the $50,000 post-trial payment. But the testimony at trial made clear that all of that $16,000, including that portion that was in that one column on the statement, was all expense related and not of the kind of payment, the reward sort of payment given after trial.
I presume that document came into evidence, and Mr. Muhammad was questioned with regard to it. Is that correct? At trial?
The statement itself was not introduced in evidence. That was disclosed after trial. But both Muhammad and Agent Carnwright testified at trial about the reimbursement or the payments, the pretrial payments that had been made to Muhammad, buying him a car, a junker car, paying some rent for him, and helping him out with other expenses. All of that was disclosed and testified to at trial and subject to cross-examination.
But the government waited until after the verdict to give the $50,000 to Muhammad. And that was hidden from the court and the defense. What that government action did in effect, it seems, but what it did, it avoided the caution and great care instruction, which the district court said it might have given had it known the true situation. Why isn't that seemingly manipulation of the jury instruction process itself problematic?
The delay in the payment, Your Honor?
Well, the fact that no one ever knew the real situation, not the district court, not the defense. And, then suddenly there's this $50,000.
What?
It's bothersome. And yet you say you would not have changed. What happened?
I certainly understand that it's bothersome. The district court was not happy with it. Judge Scudder has asked some questions about it. I'm not sure that I'm happy about it. But whether there was something to disclose before trial is a different question. And I'm not sure that there was. Agent Carnwright valued Muhammad's work that he had done for the FBI. She wanted to reward him. She could have wanted to give him a medal. She wanted to give him some money. But nothing had been set in stone. Nothing had been promised. Nothing had been approved. She hadn't done anything to effectuate this desire on her part to give him any money or reward.
Yeah, I think the disclosure, I asked the disclosure question, not put anybody on the spot or anything, because I actually think it's a very difficult question. I'm not sure. I mean, the disclosure would have been of an intent, maybe of a post-trial plan or a post-trial step that the government or the Bureau was going to take. But would it have been more than that? Because there was as I understand the fact pattern, when Agent Carnwright presented it to the United States Attorney's Office, the U.S. Attorney's Office said, effectively, put a bookmark on this until the case is resolved. So put a bookmark on it until after trial. And then, of course, after trial, it was picked up, and as Judge Rovner said, it was, there was a payment made that way. So pre-trial, the outreach to the U.S. Attorney's Office definitely shows an intent, maybe a plan, a step that was being contemplated. And I don't know the answer to the question of does that trigger then a disclosure obligation, either just under the discovery rules or under the Giglio line. I don't know.
Agent Carnwright testified that her pretrial intent was purely notional during the trial, and she made it concrete after trial. Now, perhaps her intent or desire should have been disclosed, but even so, the district court found no new trial was warranted here. Muhammad's credibility, Carnwright's credibility, was not really impacted by her unacted upon desire to reward Muhammad after trial. As the court noted, Muhammad's testimony was really largely confined to discussing the tape-recorded evidence of his interactions with Jones and Schimenti. This was all on tape. He had been cross-examined about the payments by the FBI to him, his motivation in working for the government, and so he had been crossed on those things. And the district court found that this if they had made this added disclosure, it would not have impacted the verdict. And I don't think that was an abuse of discretion. The court sat through the trial, saw the evidence, heard the arguments, and made that decision. I think it ought to be upheld. Thank you. So, if there's nothing more, Your Honor, I'd ask that you affirm the judgment.
Judge Brennan or Judge Scudder, do you have anything more to ask?
Oh, thank you.
I don't.
Thank you, Mr. Fullerton. Thank you. Mr. Van Zandt, I'm going to add another 2 minutes of your time because of, in the interest of being fair.
Certainly, Your Honor. I'm happy to answer any questions the court has until noon if we have to.
Oh boy.
Please just tell them about me, and they can ask me anything before they even meet me. It is within your power, my brother. I ask that you do so for Allah's sake. I'm tired of watching the slaughter, my brother. That is what Omar II was telling Mr. Jones in order to get him to introduce Omar II to the law. So the record's replete with things like this. These appeals, these repeated pleas, appealing to him as a Muslim, as an American, as a friend.
But, you know, forgive me for a minute. Can we just put all of this into the, you know, the time? In other words, Mr. Fullerton, well, you know what Mr. Fullerton argued. What's your view?
Your Honor, I think several things that Mr. Fullerton said really caught my attention. One was when he mentioned that Mr. Jones told Omar I think about going to Islamic State day and night. That's great, except he didn't have a passport. And he never got one. And he never tried to go. And he never did go. So to the extent that Mr. Fullerton claims that this is evidence of an intent to violate the law, this is wishful thinking. That's what Mr. Jones was expressing on every single occasion that he was talking to these individuals. He never joined ISIS. He never swore bayat. He almost didn't introduce Omar II to Bilal unless he demanded it. But going back to your question about the timeline, I think that it is where the courts have talked about this, and I do agree that it's a little bit muddled. The statements that are made afterwards tend to be relevant towards the inducement as opposed to the predisposition. But as I mentioned during the initial discussion, they're really talking about each other. So let's just take Mr. Fullerton's argument as a stand. Let's look at what Mr. Jones said and did afterwards, once the government began trying to talk to him. He rejected every overture they ever had. Everything he ever discussed was philosophical. It was argumentative. It was him asking, I'm not sure about this. When the Paris attacks occurred, and he was speaking with the undercover agents, what do you think about this? What would the Prophet think about this? He's not saying, I'm going to go pick up a gun tomorrow and head on over there to take care of this myself. There's no indication whatsoever that he was ready to commit a crime at any point up until we got to the cell phones.
Mr. Van Zandt, go ahead and finish your thought.
No, not at all, Your Honor, please.
Okay. If you try to isolate, I agree with you that the law is not entirely clear here on this, on the measurement period. Where was it? The Zion Police Department, whether we're measuring predisposition before that meeting, or whether it can bleed into the after period when the investigation the form of the investigation changes. What do you think the right answer to that is legally?
My opinion is that it is the moment that the government talks to him. That's my opinion. I think that what happens afterwards is...
And what do you know this area law pretty well. What are you grounding that in? I mean, it's informed by your knowledge of the law. What are you rooting that in?
This comes largely from Jacobson, Your Honor. The courts have talked about this in that line. I think that what's happened in a lot of other cases that haven't gone up to say the Supreme Court or something like that, it's been easy to bleed them into each other, and for good reasons. I think that it is hard. This is a really difficult question. So I think from a legal perspective, that's the cutoff, is when does the government contact him? Now, from a practical perspective, talking about it in this case, I think a better question is, when did his intent change? Mr. Fullerton said that there's no evidence that prior to the Zion Police Department that he had any intent to break the law. So when did his intent change? Did it change when he met Omar 1? Did it change when he met Bilal? Did it change when he talked to Omar 2?
Did it have to change?
I think it does, Your Honor, because
Why?
we know already that Mr. Jones was not predisposed prior to his encounter with the police, or with the government at the Zion Police Department. All he was doing was thinking. That's something that Mr. Fullerton said when he was up here a moment ago, and I fully agree. I think the district court did too. There is substantial evidence in this record.
So your point there is, despite being an admitted ISIS sympathizer and active on social media with those particular viewpoints, he had not acted on them.
That's
right?
precisely it.
He'd not taken any step to provide material support or anything akin to that.
I think the key point is he had not taken any steps or any indication he would do anything against the law. And that's where I return back to Jacobson again, is it doesn't matter whether someone is interested in something. What matters is what they do about it. And this was a comment that I think was in Evans, if I recall correctly. Yeah. This is out of Barta, excuse me. This is on 939. It's on page 14 of our reply. It's not relevant to the inducement inquiry whether additional efforts of persuasion are required because the target of the sting was too busy, too reverent towards the law, too cautious about the possibility of a government sting, or whatever the case may be. That's the issue, is was he predisposed to commit a crime, this crime, before the government spent years talking him into it? Now, at some point he obviously was, because he committed the crime. But that's not the question.
Yeah, can I,
Of course.
Judge Robner, can I ask one more question? Just the,
Please,
the-
yes, of course, always.
do you believe the government was under an obligation to make a disclosure around the $50,000 matter? And if so, what's the source of the obligation on the disclosure, and what's that analysis in your view?
One, without a doubt, Your Honor. I was, it's hard to explain how angry I was when I found out about that. It was something I never expected the government to do, and that's something that goes right to the heart of it. Now, I think that this, the district courts explained this quite thoroughly in the opinion. I think that the payment issue, obviously, itself, that happened afterwards, so the fact of payment is not something that could even be disclosed before trial. What should have been disclosed, and what I absolutely wanted to know, is what Carnwright was planning on doing and what she told Muhammad about it. One thing that really struck me as I was preparing for oral argument yesterday is the word that keeps coming up is, well, nothing was set in stone, nothing was promised. That's not really the issue here. And if you recall during the trial, one of the things that we questioned Muhammad extensively about and Carnwright about was the INS situation, the immigration situation. That was a benefit that we felt that they had worked around and tried to help them out with. So my question is, that I would have liked to investigate further, and I would have questioned Carnwright extensively about, is even assuming you didn't promise something, did you let him know it might happen? I can't make any promises, but we'll take care of you. That's a question I really want to know about, and I would have dug extensively into. And here's something else that Judge Wood said in her opinion on the new trial motion that really struck me. Carnwright was less than forthcoming at trial. Based on what we found out afterwards, she was not telling the truth about her interactions with Muhammad.
Why not bring her in as a witness then?
For the trial?
Post-trial.
They did, Your Honor.
And why, you're talking about this type of information you would have liked to have asked her.
Yeah, right, and so the post-trial briefing, or excuse me, the post-trial hearing, if I recall, was exclusively about the payment itself. I wasn't there, so that's something I can't obviously speak to. But the fact that Carnwright was able to shade her testimony in such a way to frame the government's investigation a certain way, to frame the inducements a certain way. But then we find out that there's a lot more going on underneath the surface. That goes directly to Carnwright's credibility in addition
Hold
to
on, I want to make sure, are you isolating the 50,000 issue, or are you merging the kind of the question Judge Brennan was asking earlier about the failure for a complete and accurate and complete accounting on the 16,000?
I think it's the latter, Your Honor, though to some extent I think the Carnwright's intent with respect to the 50,000 is relevant. But so far as from the legal perspective, when we're talking about Brady obligations, it's the latter, not the former. So if that makes sense.
So sure. So what you're saying then in response to the question that got us going on this is that in particular Giglio would have is the source of the due process clause. Absolutely. Is the source of the obligation because it's material to the credibility of a key witness in the case.
Precisely, Your Honor. And actually one additional point on that is not everything was recorded in those conversations between Muhammad and Mr. Schimenti and Mr. Jones. There was a key, I think it was February 6th of 2017, there was a key meeting at Mr. Schimenti's workplace that was not recorded. And that's apparently where Muhammad first raised the issue of his brother in ISIS. That was not recorded. Now, if every single interaction was recorded, we'd probably be in a different situation, but it wasn't. So this issue of non-disclosure affects not only Carnwright's credibility, but also Muhammad's. And that's something the jury should have known about, particularly given the trial court's statement about, I would have given the caution and great care instruction had I known about this. And we're talking about the government's key witness here.
So if I understand, Mr. Van Zandt, earlier in your rebuttal argument, you indicated it went right to the heart of it. And what I'm hearing now is that this goes to impeachment. It goes to impeachment of Muhammad, it goes to impeachment of Carnwright. All of this evidence with regard to the compensation of Muhammad is impeachment evidence. Is that fair?
To an extent, Your Honor, I think that's accurate on the surface. But what makes this whole thing tricky is the trial court's right. We're not talking about, is it about guilt or innocence of the substantive charge of material support for terrorism? That's not what we're talking about. The question here is, what was the government up to? Did the government induce Mr. Jones during its investigation? That's what it's relevant to. Is what Carnwright is telling us true?
So you're saying it's going beyond impeachment to inducement?
I think so. That's probably the fairest way of putting it, although it's definitely fuzzy enough. I can't really put it in one category. But I think that at least the analysis is probably more on the Giglio side than it is the Brady side, even though they're the same thing.
And then, of course, the added layer of complexity is it's now raised, the disclosure wasn't made, so we're reviewing it on appeal, we're reviewing it on the Rule 33 denial, and we have to, ask the kind of harm prejudice aspect of it too.
Absolutely, and I think that's completely fair. If we could have dealt with this before trial, I would have been more than happy to. We made the best record that we can post-trial, and I'm glad we did. I don't think I've ever had a case where we've had to do this extensive post-trial evidentiary stuff. And what we found out was kind of shocking.
I don't mean to press you too hard on that,
of course.
but earlier you indicated there were questions that you would have asked that weren't asked. Now, upon reflection, is it fair to say you're now indicating there are areas that you would have gone into that you didn't before?
That's actually a really great point, Your Honor. I was thinking about that yesterday. What would I have done differently when I was crossing Carnwright if I had known about this stuff? And that's precisely it. Carnwright was very cagey about how the government conducted this investigation. And you'll recall that there was extensive discussion in the trial about the text messages, or the internal FBI messages about, the dead horse known as Jones, et cetera, et cetera. So the way that Carnwright presented this to the jury and the way that the government argued this to the jury in closing, Muhammad is this patriotic individual who's doing this for nothing. Carnwright is standing here telling us that this was completely above board, we did nothing wrong, and this was just the way that we do things. We're finding out now that there was a lot more behind the scenes, and that's something that needed to be delved into. What that would have resulted in, obviously we don't know and we can't say. So the question then becomes, what's the standard? And this is something that we discussed a little bit in the brief, so I'll be brief about it. The way that the test is sometimes framed is it probably would have resulted in acquittal. That's how the test is sometimes framed. There's other situations where we see the test as, would it have made a difference? Is this something the jury should have heard about? Knowing this now, is this verdict worthy of confidence? And that's the way that the court's been phrasing the test. On that test, I can't say it is, because this is stuff the jury should have heard, at the very least, particularly when we're talking about a case of this magnitude and with this sort of offense. I know we've covered a lot of bases today, but I'm happy to answer any additional questions the court has. The last thing that I would say is, if the court agrees with me and decides to reverse this case, Mr. Jones has been sitting in Leavenworth for years now, and he's going to do another 14. So I would ask that if this court does agree with me, that it would order him released pending the issuance of the opinion. This case should be reversed, Your Honor.
Mr. Van Zandt, you were appointed by the court,
Yes, Your Honor.
and as Judge Scudder earlier noted, you've done a remarkable job for your clients, and you really have the deep thanks of the court for taking on this very difficult case. We also, as always, thank the government for its work and Mr. Fullerton's fine presentation. Thank you.
Thank you, Your Honor.
To all. The case will be taken under advisement, and we're going to take that 10-minute recess that I mentioned earlier. Okay. All right. The next case of the day is case 4, and it is 221336, Stant USA Corporation versus Factory Mutual Insurance Company. And good morning. Good morning. Well, yes, good morning, Mr. Ellison.
Good morning, Your Honor. May it please the court. The Stant appellants seek reversal of the district court's opinion dismissing their complaint, seeking coverage under their factory mutual insurance policy for pandemic-related damages. And this is an Indiana law case. The fundamental goal under Indiana law in interpreting an insurance contract is to enforce the party's intent as manifested in the language of the contract. And that's a critical point here, Your Honors, because this contract is different than all of the other insurance policies that have been dealt with to date by this court and by the Indiana courts for some very critical reasons. Those policies all provided coverage for all risks of direct physical loss. And this policy does not, one, contain the word direct, which connotes a more expansive and broader coverage to the parties that buy the factory mutual policy, including the Stant appellants. And the other important distinction with this policy is that it includes the all risk language as the introductory portion of the policy in the coverage grant. Now,
in distinguishing our case law, you argued in the brief that the language here does not require that physical loss or damage be direct, but the policy excludes all loss or damage that is indirect or remote. So how is that materially different from limiting coverage to direct physical loss or damage?
Your Honor, in the coverage grants that were at issue in Circle Block and in Sandy Point and the other cases that have been decided, the coverage grant explicitly says that coverage is provided for all direct loss caused by direct physical loss or damage. That does not appear in the language of the factory mutual policy. If you look at the appendix at page 33, page 33, the initial insuring agreement says that the policy insures all risks of physical loss or damage. It does not include the word direct.
But then when you flip to page 46, right, as Judge Rovner was pointing out, the very first exclusion in A1 is of indirect or remote loss. So as a practical matter, if indirect loss is excluded, you would say what is included? Direct.
Fair enough, Your Honor, but the other part of the policy that this does have, which the other policies do not, is the all risks language. And in the Indiana repertory theater case that was decided by the Indiana Court of Appeals, and there's another appeal on that action, which was supposed to be argued last week but got postponed. But in the first appeal, the court in its ruling made a distinction between a policy that does not have the all risk language in it, suggesting that if the all risk language had been in the policy it was considering in that case under Indiana law, it may have made a difference as to what it considered physical loss or damage.
Under your theory, could coverage be triggered every year based on the flu virus, which also is deadly and can survive on surfaces?
Your Honor, the answer to that question is yes under this policy, because this policy explicitly provides coverage for communicable diseases. And if we go to the body of the policy, first under the property damage section, which starts on page 45 of the appendix, if we continue on to page 52, under the additional coverages for property damage, the policy explicitly says, this policy includes the following additional coverages for insured physical loss or damage. And one of the additional coverages that appears on the next page, which is page 53 of the appendix, is communicable disease response coverage. And communicable disease response coverage is available to a policyholder if they can demonstrate the actual, not suspected presence of a communicable disease which prevents, limits, restricts, or prohibits access to a property by order of a relevant government agency. So that is an explicit statement in the body of the policy that a communicable disease, and the definition of communicable disease is found in the appendix at 106, and that would include COVID and the flu, Your Honor. It is an explicit reference that a communicable disease can cause physical loss or damage that would trigger the coverage of the policy. We have a similar reference under the time element portion of the policy, which begins on page 74 of the appendix, and on page 84 in the time element extensions, there is a specific coverage grant for interruption by communicable disease. Again, this is a unique distinction for the factory mutual policy compared to the Zirko block or Sandy Point policies that had no reference to communicable disease in them explicitly as it appears in this policy in two separate locations.
You see, you rely on cases in which a danger to health rendered a property unsuitable for use, such as those that involved asbestos, gas vapor, ammonia, E. coli, brown, recluse, whatever, spiders. But in all those cases, it was the property itself that rendered a threat to health that was not present generally in other properties. Here, none of the properties pose any COVID threat greater than the threat that is presented at all properties generally. Doesn't that make clear that the property itself isn't the cause of the health threat here, unlike the cases that you cited?
No, Your Honor, I don't think it does. And one of the reasons for that is if you look at the communicable disease portions of the policy I just directed you to with respect to property damage and time element, they both relate to preventing access to the property and the presence of the communicable disease preventing access to the property. And what we have alleged and what the orders that we've cited in our complaint precluded was access to the property. And I think it's also important to note that access does not need to be completely precluded. In both of the communicable disease coverages that I referenced, if access is limited, restricted, or prohibited, so it's any of those three is sufficient to trigger coverage under the policy. It doesn't need to be complete access that nobody can get in, but if there is a restriction on use caused by a communicable disease by order of a government agency and the actual presence of the virus can be shown to exist at the property, that is sufficient to potentially cause physical loss or damage within the meaning of this insurance contract. And the interpretation I'm offering is not a novel one. And it has been accepted as recently as last Thursday by the federal court in a supplemental authority we submitted to your honors yesterday in the Sacramento Downtown Arena decision. It's also been accepted with respect to other FM policyholders in the Cinemark case and others that we've cited in the brief. So this is not some unique interpretation that we're offering here for the first time under Indiana law, but it's one that has been adopted and recognizes other courts as at least sufficient to allow the claims to go forward into discovery to see whether the policyholder can prove their case. And that's all we're asking for here, is that this interpretation that we're offering could qualify as a reasonable one that's enough to get the complaint past a motion to dismiss. And with that, your honors, I'd like to save the rest of my time for rebuttal, if that's okay.
Sure. Thank you very much.
Thank you.
Hey. Good morning, Mr. Mastoris.
Morning.
Good morning, may it please the court. George Mastoris on behalf of defendant Appellee, Factory Mutual Insurance Company. Stant has raised a panoply of different arguments both this morning and in its papers. I'm going to try to focus on the ones that actually came up over the last 10 minutes because I think that's where we probably should go. But before getting there, I do want to point out that I think all of these arguments are foreclosed by this Circuit's decisions. First and foremost, by the Zirko block case, which applies Indiana law and deals specifically with the question of whether COVID-19, the virus which causes COVID-19, actually do constitute physical loss or damage. The answer there was a resounding and definitive no under Indiana law, as interpreted by the IRT, by the Court of Appeals in the IRT case, and by this circuit as well. I think the arguments that are also made have been foreclosed by other decisions in this circuit, which this court in Zirko block found that the laws of Illinois, for instance, do not differ in any material respect from that of Indiana. So see Sandy Point Dental and the Mashallah case in particular. So there are the main issue, I guess, between us and the main issue that plaintiff appellant raised is this one of physical loss or damage. The first argument, I believe, was conceded, which is that the absence of the word direct between the words physical loss or damage in the FM policy makes no difference, thanks to the very first exclusion in the policy for indirect or remote loss or damage. The second argument that was made has to do with the fact that this is an all-risk policy. Now, the IRT case does distinguish a number of pre-pandemic cases on the basis they do not involve an all-risk policy. That is true. That said, those cases can also be distinguished on the grounds that they involve a complete loss of habitability. The thing is, in Indiana, there has not been a recognition that that itself does constitute physical loss or damage. Rather, Indiana follows couch in saying that there has to be some sort of structural or tangible alteration to property. But the fact is that whether or not plaintiff appellant is right here, and in fact the mere risk of unactualized physical loss would be enough to trigger coverage, that doesn't make a difference, because if COVID-19, when it's actually present, cannot trigger physical loss or damage, does not constitute physical loss or damage, the mere possibility of COVID-19 also can't seem to trigger a finding that there has been physical loss or damage. Moreover, in the article, which I believe was written by a colleague of counsel for plaintiff appellant, the Lewis article, which they cite in their brief, I think that's Appendix 122, there is a footnote which explains what an all-risk policy is. And all that means is that coverage is sort of a general grant, and there's various exclusions. So all fortuitous losses is what an all-risk policy means. Then there are certain exclusions which say, okay, these things are not covered, but all other fortuitous losses are. That's one of the two main types of insurance policy. The other is a named peril, where the insurer actually goes down a list. Flood is covered, fire is covered, etc. That's all risks means here. And I would also point out the Sandy Point Dental policy was an all-risk policy. The Mashallah policies were all-risk policies. The Roundabout Theater policy, which is relied on by IRT in reaching this decision, was also an IRT policy. There's no real there with regard to that argument. The third point...
go ahead.
No, I'm sorry. No, please. Because I was going to move to a different point, so...
Okay, with the policy language regarding physical loss or damage cover cases of mold infestation or outbreaks of Legionnaire's disease at a particular property where measures had to be taken to address the conditions that caused the outbreak. Before that particular property could be habitable again?
I think the key is actually found in the language of the policy itself, Your Honor. So the policy has a period of liability provision, which is well-nigh identical to the period of restoration provisions that we saw in Sandy Point, for instance, and in the Zirko block case, which was decided under Indiana law. And what it says is it directly ties the idea of physical loss or damage to the idea that something has to be capable of repair or replacement. And this court has decided repair or replace does not describe cleaning measures that can be taken or the natural dissipation under which COVID disappears over time, and which Stant's complaint here also concedes that it disappears within a matter of hours or days. So I think the question that you ask, Your Honor, would depend on the facts of the case. If there has to be some repair or replacement of actual physical property, then under the policy, yes, that could be physical loss or damage. If as here, there is no need to repair or replace the policy, then there isn't physical loss or damage. And this court has already found that to be the case with respect to the virus that causes COVID-19. If I may just continue with the third point that counsel made, which had to do with the communicable disease provisions. And I believe the argument is elucidated this morning and also in their briefs, is that because Factory Mutual has chosen to provide a very limited coverage for communicable disease, and in particular for communicable disease not on its own, but the actual presence of communicable disease when it's present, when it results in a shutdown of the property for more than 48 hours, there is certain limited coverage available. Rather than the $500 million that Stant has as the total policy limit, there is $1 million of coverage afforded. So there's a couple of issues, I think, with reasoning from the fact that FM provides this $1 million in policy to the fact that the mere presence of a communicable disease, even without the shutdown, even without the 48 hours, should somehow entitle them to $500 million. In and of itself, that seems an unreasonable interpretation of the policy. The prefatory language in the additional coverage section says also that the reference to insured physical loss or damage is, quote, subject to the policy provisions, including applicable exclusions and deductibles. Here, there is a contamination exclusion. So these coverage are subject to the contamination exclusion in this case, which bars any coverage and any recovery for contamination and any cost due to contamination. The only narrow exception to that is the precise communicable disease coverage if you've got the presence of the disease on premises and you have to shut your premises down for more than 48 hours, you get $1 million in coverage. Otherwise, the exclusion bars recovery for the mere presence of contamination on your property, and that's a second affirmative ground on which this court could affirm the district court's decision below. Another issue with that argument also has to do with the internal logic that it seems to suggest, right? There are 24 different additional coverages. 23 of them refer specifically to physical loss or damage and the need for physical loss or damage. The only one that does not is the communicable disease provision. So under the rule of surplusage, which I believe features fairly prominently in Stant's brief where they try to compare this policy to the one in Sandy Dental, that rule is one that applies intracontractually. Here, it's got to mean something. The 23 out of these 24 coverage contain that language, and one of them does not. Further, the idea here is that because there's a heading which says communicable disease response, which requires these other things, that somehow each of those headings, I guess, under that logic, would also have to constitute physical loss or damage. But I'd invite the court to take a look at the other additional coverages, many of which could not possibly constitute physical loss or damage on their own, which is the argument here. So for instance, brands and labels, right, is an additional coverage. Errors and omissions, expediting costs, currency. I could go on, but none of these in and of themselves are in fact physical loss or damage or constitute physical loss or damage. And yet that's precisely the argument that plaintiff appellants are making here. It is also an argument, I'm not sure the case was cited in any of the briefs, but it was an argument that was rejected on those terms specifically by the District of Connecticut in the ITT case, and I can get that citation for the court if you would like. I'm sorry. There were no questions. I was expecting one, I guess. The only other thing I would add with the balance of my time is, again, just to reiterate, the contamination exclusion does provide a separate bar to coverage. So even if, by some reason, this court should find that somehow Stant could make a claim for physical loss or damage under Indiana law, despite the finding, despite the holding in Circle Block, the holding in IRT, and the holding in its other precedents, the contamination exclusion here is quite broad. It covers viruses, it covers pathogens, pathogenic organisms, it covers disease-causing agents and illness-causing agents, and it covers contamination at all costs due to contamination. There's simply no way around the breadth of that exclusion other than the very specific coverage which Factory Mutual has chosen to provide for precisely situations like this one, the spread of a communicable disease and the forced shutdown of a property. The fact that FM chooses to provide that coverage and sublimits it to $1 million should not somehow open up and unlock the remainder of the policy up to the full policy limit, which is precisely what plaintiff appellants are arguing. With that, Your Honor, I will rest unless there are any questions. Thank you very much.
No, thank you very much. Mr. Ellison, you asked for 2 minutes. We'll give you your 2.
Thank you. Thank you, Ryan. And I'll try to cover everything. I'll start with Indiana law requires looking at the actual language of the policy. If you look at page A52 of the policy in the property damage section, it expressly says this policy includes the following additional coverages for insured physical loss of or damage. And directly underneath that appears the communicable disease property damage provision. It couldn't be clearer or more explicit that one of the causes of loss that could qualify as physical loss or damage is a communicable disease like COVID-19. This policy also does not require complete loss of use, but only limited or some restriction on use caused by a government order. On the period of liability point, Factory Mutual only cites the one measure of loss under the period of liability provision. There are many more, and one in particular is of extreme importance to this case. At page 82 of the appendix, the period of liability for measuring the loss of gross profit is not measured by repair or replacement. It is measured simply by time. And that provision provides that the period of liability applying to gross profit starts from the time of physical loss or damage of the type insured and ending not later than the period shown in the limits of liability clause of the declaration section, during which the results of the business shall be directly affected by such damage. So that is a period of liability provision that has nothing to do with repair or replacement, and is a portion of the policy under which Stant is entitled to seek coverage, whether it needs to repair or replace anything, if the trigger for physical loss or damage by communicable disease is satisfied. One last point. Under the communicable disease provisions, there is an exclusion for terrorism to both of them. Now, if there was no coverage for physical loss or damage caused by communicable disease, there would be no need to have an exclusion for terrorism, because the policy would never be triggered for physical loss or damage caused by communicable disease, according to Factory Mutual. But they instead recognize that coverage for physical loss or damage caused by communicable disease can be provided by this policy, and then exclude from that coverage communicable disease that impacts property that is caused by terrorism. That is a fatal drafting admission by Factory Mutual that this policy responds for communicable disease exactly the way that we've pled in the complaint, and we ask that you reverse the district court. Thank you very much. Thank you.
Thank you. Thank you very much, Mr. Ellison. Thank you, Mr. Mastervis. We are going to take the case under advisement. We're going to go on to the fifth case of the day, NLRB versus Jam Productions Limited. Thank you. Good morning, Mr. Garfield.
May it please the court, good morning. I'm Garrett Garfield, representing the respondent employer in this case, Jam Productions. This is a vote-buying case where the NLRB unreasonably certified the results of a certification election and then followed that with an order that Jam bargained with the union. This court should overturn both orders because in the months and the weeks leading up to the election, the union exercised its discretion to funnel disproportionate numbers of lucrative job referrals to a key block of voting employees. That was a grant of tangible economic benefits in the crucial period leading up to the election that compromised the laboratory conditions of the election and required that it be overturned.
Mr. Garfield, what particularly was wrong with the way the two trends in the law got synthesized here?
What was wrong with that? So I believe Your Honor is referring to what's on page 11 of the board's decision, talking about its reconciliation of certain hiring hall cases with the B&D plastics factors.
Correct.
What's wrong with, there are two things wrong with that. First, the board imposed an unprecedented burden on Jam, where Jam would have to show not only that a benefit was granted in the critical period, but also that the voters were not entitled to that benefit. That wasn't necessary here because B&D Plastics already set out the framework for dealing with discretionary grants of benefits in the critical period, and holds that when there is such a discretionary grant, then there is at least an inference of objectionable conduct. So the board did not need to reconcile those cases to decide this case. Second, on the facts, JAM met that standard anyway because the evidence was clear here that the referrals were discretionary. The union admitted that, and that no one was ever entitled to any referral from the system because the referrals were given solely in the board's discretion, the union's discretion, excuse me.
Now, the evidence relied, did you want to follow up?
No.
Judge? No, okay. The evidence relied upon by the board included evidence that the total number of referrals to the Riviera voters actually decreased sharply in the last 3 5-day periods before the election, and increased again later in the summer following the election. Isn't that evidence that the referrals were not allocated as an inducement for the vote in the election?
No, it's respectfully, Your Honor, it isn't. And if I may back up briefly, the context of this case is that we were here in this court before, and at that, as Your Honor well knows, and at that point, the raw numbers of referrals were shown to have increased generally throughout the critical period. So the answer to the question is, although the raw numbers were the smoke, but the real fire here was the disproportionality in the referrals that were granted to the voters as compared to others in the system. And this is in our brief on pages 17 through 21, and I don't want to belabor the numbers or the ratios themselves because the arithmetic itself is not at issue. But what I would like to emphasize is the point that the comparisons are not close. When we look at the different comparisons between voters, let's say voters who recently enrolled in the system and others who recently enrolled in the system, we see 3.5 times as many referrals going to voters as to those comparators. If we compare, say, voters versus non-voters, we see 3 times as many referrals being directed to the voters during the critical period before the election. And that was one of the board's fundamental errors here, was to ignore or to misconstrue that key numerical evidence. And the board did have, the board's first response to that was to observe that the raw numbers of referrals to voters did generally rise and fall in tandem with the raw numbers of referrals being given out of the system generally. But the problem with that is that it misses the fact that the voters were getting a disproportionate share per person. This was not a case, in other words, where a rising tide lifted all boats equally. It was a case where the union exercised its discretion to ensure that some boats, the voters' votes, were lifted more than others. The other error that the board made, or the failure to base its finding on substantial evidence, is that even when it did engage with this evidence of disproportionality, it casually dismissed it. This is primarily on page 14 of the board's opinion, but it dismissed this evidence based on its own conjecture. For example, in one of the comparisons I just mentioned, the voters versus the non-voters, the board said, well, maybe it's the case that the voters had more experience and that could be the reason that they received more referrals. And the problem with that is evident on its face, and it is that there is no evidence to that effect in the record. The board's finding there was not based on the substantial evidence. The substantial evidence that was in the record was that the voters were in fact favored based on any comparison one wants to draw during that crucial 6-week period leading up to the election in May of 2016. The numerical data was not the only evidence in the record either, and we cited in our brief some of the other points that bolster the conclusion that the union did exercise its discretion to target and favor the voters. One in particular where I'd respectfully request that the court direct its attention is to the evidence that the voters were referred to jobs in groups, not once or twice, 15 times during the relevant period. This highlights another one of the board's key errors or failures to base its finding on the substantial evidence, because the board uncritically credited the union's testimony that it couldn't have favored the voters because it didn't know who they were. These numbers are in our brief, and I don't wish to put too fine a point on it, but that testimony is proved false by the fact that the voters were referred in groups to jobs. To any level of statistical certainty, that cannot have happened unless the union knew who the voters were and used that knowledge when making the referrals.
Mr. Garfield, let me ask you to react to this. Are you sure you're not holding the board to a higher standard than the law does?
I am sure of that.
Because the reason I say that is because what you're doing is you're saying we have conducted a statistical analysis where we're focused on, relative referral rates, right? That's the whole the basis for the disproportionality points that you're making and that you made in your brief that way. But the hearing officer held a hearing, heard the account of, what's his name, Herman? Mr. Herman?
Mr. Herman, yes.
And I think Mr. Carlson, but definitely Mr. Herman, on this, and did look at this statistically, not with the rigor that you are advocating was required, in a more elementary way with that trend line chart A thing, table A. But under the substantial evidence standard, which is pretty deferential that way, why couldn't we conclude it was enough? They did enough on remand. Could they have done more or better? Perhaps, but they did enough. What's wrong with that?
Your Honor, the reason they didn't do enough is that their assessment of the evidence has to be reasonable. It is not reasonable to effectively disregard the statistical evidence and to give it no weight based on its own conjecture. I would respectfully direct the court's attention, for example, to the King Electric case, where the court similarly had disregarded circumstantial evidence, and also to the River City elevator case, which is a similar case involving a pre-election grant of benefit by a union. So I take Your Honor's point. The standard is tough. River City did in fact call it a formidable burden, and yet it's still overturned. Still overturned because the union had granted a benefit to which the voters were not entitled. I see I'm very low on time. I'll request to reserve my remaining time unless there are further questions. Thank you.
Thank you very much. Mr. Side.
Good morning, Your Honor.
Good morning.
May it please the Court, David Side for the Labor Board. The Board reasonably applied a two-step analysis in overturning JAM's election objection that referrals to the Riviera voters during the focal period, the 6 weeks prior to the election, was an impermissible benefit. First, the Board found that referrals to non-members was not a new benefit, and that JAM further failed to carry its burden of establishing that there was disproportionate referrals provided to the Riviera voters during the focal period. Under the second part of its analysis, the Board determined that even if the referrals could be construed as a benefit, the union established that the referrals were due to workload, not the upcoming union election. Those conclusions are fully supported by substantial evidence, consistent with this court's remand, and consistent with other cases of the Board and the courts.
Now, JAM argues that the Riviera voters received twice the number of focal period referrals as other non-members. based on a total of 827 non-member participants in Cole Stewart. You argued that the number for comparison should only be the 334 non-members. Just quickly explain why that number is the proper comparator.
Correct, Your Honor. So essentially, JAM has tried to, or has alleged that the board erred in failing to draw certain inferences based on the referral numbers. And one of the referral numbers that it talks about is it compares the number of referrals that were received by the JAM voters during the focal period with all of the potential people who are participating in the hiring hall. However, it's not clear that all of these individuals were eligible for work at this time or even seeking work at this time. And as the board's decision aptly notes, JAM did not ask a single question to the union's witnesses about the people who did not receive or might not have received significant referrals, whether they were searching for work, whether they were even eligible at that particular time as far as being available for work. And so in that context, the board very reasonably looked at the total of non-members who actually received referrals rather than the entire list where it's clear from the evidence not everybody would have been available or even participating in the hiring hall.
So the broader conclusion you reach from that is that you say, well, Mr. Garfield, he's offered his proportionality analysis, but the proportionality analysis just doesn't hold up. It's not a situation where you say, well, I agree, they were getting referrals at the rate of 2 or 3 times as much. I mean, you're saying I'm not accepting the premise of it.
That's correct, Your Honor, and I don't want to get too far into the weeds because it is covered in the board's brief, but another example, and was just referred to in opening argument here, was that those who joined the hiring hall back in the fall of 2015 as non-members received fewer referrals than JAM voters who had also joined the hiring hall back in the fall of 2015. That number may actually be accurate, but again, it doesn't take into account, as the board's decision sets forth, were some of these people available for work at that time? Were they even seeking work at that time? And JAM did not ask, again, a single question to the union witnesses about this alleged disparity. And then, as the board's decision sets forth, if one looks at the Riviera voters who joined closer to the election, when compared to other non-members who became participants in the hiring hall closer to the election, the other non-members actually averaged more referrals than the JAM voters who became participants closer to the election. So that certainly raises doubt about JAM's numbers, and it was certainly not improper for the board to decline to draw the inferences that JAM insists the board should have made.
The board relied on testimony that the practice for union referrals involved the consideration of factors such as availability, experience, skills, and union membership. But is there any objective evidence that such factors were considered as part of the process as opposed to resorting simply to whim or some sort of unfettered discretion?
Your Honor, the testimony from Call Stewart Herman was consistent. It was repeated. Yes, there's discretion. It's a non-exclusive hiring hall. So by definition, there is discretion in a non-exclusive hiring hall. He was consistent in his testimony that both prior to and during the focal period, he considered the same factors, primarily availability, experience, skills, and tending to favor union members and those with more experience. And in fact, the documentary evidence supports that at all times. whether viewed at Table A in a 5-day period, whether viewed on a daily basis at the appendix pages A80 and 82, the union members received the most referrals, followed by non-members, with a very small percentage of those being the Riviera voters. And again, the JAM's own documents, which can be found at page 80 to appendix page 80 to 88, which sets forth when people started and the number of referrals they got. There were actually JAM non-voters who started in April. This is at page 87 of the record. There's 2 Alvarez's, a Bartolini, and a Baminas. Got 16, 10, 11 referrals, more than many of the JAM voters themselves.
Those 2 individuals are non-voters?
Those were Riviera non-voters. Then there's Jonathan Harvey, who's a non-member, nothing to do at all with JAM. Starts on April 1st, 6 weeks before the election. He gets 27 referrals, more than any of the voters, in fact, I think more than any of the non-voters. So this all goes to show that this was a natural ebb and flow. There were some major events going on in April, particularly the NFL draft, and as was earlier noted, right before the election, right when the union would be expected, boy, if we want to favor our potential voters, here's the time to do it. The referrals to those voters cratered, and then it dropped significantly after the election before picking up again and actually exceeding the focal period well into the summer, which supports, again, the overall finding that this was simply an ebb and a flow of work, that the spring was a busy time period, and then the summer picked up again, and that's when more referrals were seen to all types of voters, whether they were Riviera voters or non-voters or non-members that had nothing to do at all with Riviera. Unless this court has any further questions, the board would simply ask that the court enforce the board's order. Thank you, Your Honor.
Thank you, Mr. Sy. Mr. Garfield?
Thank you, Your Honor. I'll be very brief. The argument about ebb and flow of work is repeated in the briefs. It was repeated in the board's decision, but it does not answer the fundamental question of disproportionate treatment. It may answer the question of the raw number of referrals. It cannot account for the disproportionality.
Can you speak on that point, Mr. Garfield? Can you speak to Mr. Side's argument that, yeah, I hear you on disproportionality, but your measure is infirm? Because of the point of you're not accounting for the availability or lack of availability of those all within the pool of the hiring hall.
Sure. This is the question of whether 820. In short, it's whether 827 should have been the denominator for our calculation.
Because I think he's saying your proportionality analysis, or the board's view of it, is that it's not accounting for an important variable.
A couple of responses to that. One, there's no evidence in the record as to which of those workers may or may not have been seeking work. The evidence that was in the record was that there were 827 other non-union members in the hiring hall. The other thing to consider here, which is important, is that the referral system is a zero-sum game. On every day during the critical period, there were more available stagehands than there were jobs. And that means for every single person, stagehand, who got a referral, some other stagehand did not. And that's the reason you have to count the ones who didn't get a referral to have a fair comparison when you're matching those numbers. Third response to that point is that the comparison between the voters and the other non-members was only one of the comparisons we drew. We drew others, and in every case, the disparities are stark. I would respectfully direct the court's attention to the disparity between voters and non-voters. 5 times as many during the 8-month lead-in, and continuing 3 times as many during the focal period. Even if there's a little bit of noise in the data, the consistent disparities in all of the different comparisons are what reveal the problem here. Thank you.
Yes. Thank you very much to both Mr. Garfield and Mr. Syed. Case will be taken under advisement. And we are going to go on to the very last case of the day, and that is 21-1389, Stephen Zirko versus Karen Rabideau. Mr. Richards.
Thank you, Your Honor. Your Honor, I hesitate to call any case simple, but I think this is a relatively simple case. As Your Honors are aware, Stephen Zirko filed a suit claiming that prison officials had failed to protect him from an attack and from a danger that he had alerted them to. The case comes on summary judgment. Obviously, a lot of the inferences and the twist is against summary judgment. All facts are construed in the plaintiff's favor. In addition, I've cited some case law which I think is possibly honored more in the breach than the observance, but it's very important in that questions of subjective intent are rarely to be decided on summary judgment. In this particular case, even more so, because Stephen Zirko testified at a deposition. He testified really without contradiction that the remaining defendant Shaw, he had a threat from his roommate or cellmate that the cellmate was going to beat him, Zirko, within an inch of his life. He conveyed that threat to Shaw, and Shaw, and I think this is unrebutted, or at least must be taken as true for purposes of summary judgment, said, basically, we've moved you twice, solve your own problems. If that isn't deliberate indifference, I don't know what is.
The thing that I think stands out to me that I'd benefit from hearing you speak to, Mr. Richards, is the passage of time. We don't know exactly when that complaint occurred, right? We have an approximation of the November, December, 2015, is it?
I believe you're correct, and it
but
doesn't.
Then we don't have this. We have the injury is sustained in the first part of January. But is there anything in the record that shows that there was an in-between communication to Officer Shaw?
No. In fact, Mr. Zirko made some more generalized complaints to other people, but those people are no longer in the lawsuit because the complaints were too generalized. They were things like he's a drug addict, he's a bad guy, et cetera, et cetera. And I don't think those things are.
So then you can say it's not the right question, but the question that pops into my mind is, as of January 10th, 2016, when this unfortunately happened to Mr. Zirko, doesn't he have to show that at a time close to that he was aware of objectively a risk posed to Mr. Zirko, and then he subjectively declined to address it?
Well, I think the point of staleness, as I read the case law, has to do with if you make a complaint and the complaint is vague, non-specific, conclusory, then, or if you say you're complaining about something, this is a threat that happened 5 months ago, 6 months ago, I'm generally afraid of this guy, then the courts have sometimes said, well, that's stale, it's no longer objectively a threat. But this is a case in which it's not that there's a huge gap between the threat and the complaint. According to Mr. Zirko, they're close in time. He got the threat, he complained.
Well, he said about a month or so, right?
I think it was about a month or so between the time of his complaint and the time he was actually injured. Let me just check what I have as the record is of that.
A month or two. I don't want to get you sidetracked on this.
No, I understand, and I think the record will...
It's footnote 2 of Judge Tharp's opinion, what I have in mind. Zirko testified that he told Officer Shaw that Pelagi had threatened to beat him, quote, a month or two prior to the incident.
Well, yeah, but in other words, as you read that sentence, I think what it means is that a month or two prior to the incident, the threat had occurred, not that he had delayed a month or two reporting the threat to Shaw.
Yeah, no, I don't sense there was any delay in reporting it. What I sensed is that when he was reporting it, he reported it to Shaw. Shaw said nothing. Said what he said, and take the allegation he did nothing. But then a month or two went by, and then we get to the January 10th, 2016 date.
Right, and I think that goes, if it goes to anything, as to causality. There might be an argument at trial that, that the gap in between those two events, the complaint and the actual attack, is such that one could conclude that the danger had passed, it had dissipated, something of that sort. But I think that's a factual dispute, which is not to be resolved upon summary judgment. I think we're now in agreement, I can see, Your Honor, that the gap is between the complaint and the attack. The gap is not between the threat and the complaint. Right. I think a gap between the threat and the complaint would be a better argument that objectively there's not a problem, for one thing, because you're waiting months and months to complain with this guy still in your cell. According to Zirko, he was threatened, he complained, and nothing was done. And again, had the situation reversed, in fact, if we had moved for summary judgment, we might have had an argument, because there's no real refutation in the record that Shaw said what he said, which is, I moved you twice, deal with your own problems. You can tell an inmate deal with his own problems, but you can't tell him deal on your own with a threat of violence, specific violence from another inmate. And that's exactly what happened here. So for those reasons, and I don't think there's much more to be said on any topic, the motion for summary judgment should be reversed. Now, there's a lot of back and forth in the briefs about different cases. There are some with facts more extreme. There are some with facts much lesser. I would suggest to you, This Honor, that this fact pattern falls in between some of the cases which have found liability and some of the cases which have not. But it's far closer to the cases that have found liability. There's a specific inmate named. He's a cellmate, a specific threat named. Not just I don't like him or I'm afraid of him or whatever. And there's a specific response which is indicative of deliberate indifference. So for all of those reasons, I also am mindful, and I would agree with the appellees, that you can't really use the cases as a laundry list of, and make exact comparisons and find that there should be a finding in liability of one case and not another, or a finding in summary judgment of one another. They're very factually specific. There's all sorts of different situations. This one falls within the sweet spot, and therefore a summary judgment should have been denied. I see I have some time left. If I'm open to further questions, but nothing else that I need to argue.
Reserve it.
I reserve it. Thanks.
Morning, Ms. Citron.
Good morning, or perhaps good afternoon soon.
Good afternoon, right.
All right. Good morning, or good afternoon, Counsel. May it please the Court. Assistant Attorney General Chai Citron, on behalf of Defendant Appellee Joel Shaw, a former staff member at Stateville Correctional Center. Summary judgment was proper on Mr. Zirko's failure to protect claim under the Eighth Amendment because a jury could not reasonably find that Mr. Shaw was deliberately indifferent to an excessive risk to Mr. Zirko's safety.
Now, the district court granted summary judgment saying that the threat was too vague and generalized. to establish that Shaw had knowledge of a serious risk of harm. Does the record reveal whether Shaw engaged in any discussion as to the threat that had been posed, or asked for any details to assess its seriousness?
No, Your Honor. The record does not reflect that Mr. Shaw took any action after hearing the reported threat from Mr. Zirko. That I don't believe that is sufficient to show deliberate indifference, however, because the duty to investigate or take any action is only triggered if the evidence is such that the reason that Mr. Shaw knew that Mr. Zirko actually faced a serious threat of excessive risk. So the fact that he did not take any action does not mean that he was deliberately indifferent. And given the circumstances here, it would have been speculative for a jury to find that Mr. Shaw knew that Mr. Zirko faced an actual danger at the time that the fight between Mr. Zirko and his cellmate actually occurred.
You noted that Pileggi had not been disciplined for fighting since approximately 1998. But is there evidence in the record that Shaw was aware of that history?
I don't believe that the record reflects whether Mr. Shaw was aware of the cellmate's disciplinary history or lack thereof, but the record does show that Mr. Shaw was aware of several other circumstances that rendered the reported threat just not plausible. So just to give you a couple of those circumstances, one is that in that 1 to 2 month interim between when Mr. Zirko reported the threat and when the fight occurred, there was no evidence that Mr. Zirko ever repeated to Mr. Shaw, or to anyone else for that matter, that he was in danger or that he requested protective custody, that he sought any sort of emergency help, let alone that Mr. Shaw was aware of any of those requests. And there was also no evidence that Mr. Zirko could not have repeated his request for help or requested protective custody. And the evidence also showed that when the fight occurred, Mr. Zirko and his cellmate had been celled together for approximately 9 months without any incident. So there was this long period of peaceful coexistence. And the record showed that Mr. Shaw was aware of that because, as Mr. Zirko testified, Mr. Shaw allegedly said, "I had to move you already or someone around you twice. We deal with your own problems." And just to address that alleged statement by Mr. Shaw, I don't think that a jury could infer deliberate indifference from that alleged statement, given the surrounding circumstances. I think a jury would have to infer that Mr. Shaw knew that Mr. Zirko wanted a different cellmate, and that's what he was requesting. But I think it would be speculative for a jury to find that Mr. Shaw knew at the time of the fight that Mr. Zirko was actually in danger, as opposed to having merely wanted a different cellmate. And that's because, as I mentioned, Mr. Shaw was involved in the previous successful transfers, so he knew that Mr. Zirko knew how to request a transfer successfully, and also he was aware of the fact that during that 1 to 2 month period when the threat did not materialize, he was aware that Mr. Zirko never requested further help and never offered further detail about the alleged threat.
But don't we have to take the complaint that was made to Officer Shaw for what the plaintiff says that it was? It wasn't, "I'm looking for a new cellmate, we're not getting along." It was rather, the guy threatened to beat me or kill me that way, right? So we take it on the terms that Mr. Zirko reports this.
Right, that's correct, Your Honor, that the court has to take that as true that Mr. Zirko said that, but prison staff are not required to believe every profession of fear by an inmate. So, and unfortunately, it's not uncommon for inmates to complain about their cellmates, and not every reported threat is true.
What would you make of a fact pattern where that report occurs today and the beating occurs tomorrow morning? Same exact fact pattern.
I think that it would be obviously a much closer case, but I don't think that a jury could find that Mr. Shaw actually knows that Mr. Zirko is in danger, given the surrounding circumstances. The fact that Mr. Zirko and his cellmate have this long history of peaceful coexistence, the fact that Mr. Zirko has this history of successfully requesting
And there's evidence
transfers.
that Shaw knows of the long history of the peaceful existence?
I believe so, because the testimony from Mr. Zirko is that Mr. Shaw is the one who says, I've already had to move you twice. So if he knows about that movement, then he should know how long they've been together. And then the other facts that I think are relevant to this are that he knows that Mr. Zirko has this history of successfully requesting transfers. So, and there's no evidence, so he knows that Mr. Zirko knows how to give the correct information or necessary information, such as explaining why he thinks that his cellmate wants to attack him. And he also, or he could have requested protective custody. Sorry, just lost my train of thought there. And also in the fact pattern that Your Honor posits, if there was any evidence that Mr. Zirko could not, follow up immediately by providing more information or reporting the threat to others, immediately, I think that would be a relevant factor. But in our case, there is no such evidence that that Mr. Shaw somehow prevented that from happening, or that any other circumstances prevented Mr. Zirko from following up appropriately. I'd also like to point out that besides for the lack of evidence that Mr. Shaw was aware of any supposed reason for the threat, there was also no evidence that Mr. Shaw was aware of any other alleged complaints about the cellmate, either by Mr. Zirko or by anyone else. And there was also no evidence that Mr. Shaw was aware of any other circumstance that could render the threat plausible, such as any unusual behavior by the cellmate or any recent violent incidents involving that cellmate. So considering the evidence as a whole, the district court correctly concluded that it would be speculative for a jury to find that at the time of the fight, after this long period of peaceful coexistence and lack of follow-up from Mr. Zirko regarding this alleged threat, a jury could not find that Mr. Shaw knew at that time that the cellmate posed an impending risk of serious harm to Mr. Zirko. Unless the court has any further questions, we respectfully request that this court affirm the district court's judgment.
Thank you.
Thank you.
Thank you very much, Mr. Richards.
Your Honor, just quickly, as
Mr. Richards asked for 2 minutes. Just make it a thanks.
Oh, okay. Thanks for the 33 seconds or whatever.
Right.
In any event, Your Honor, just to address a few particular points. As Your Honors, I think, have already guessed or gleaned from it, Shaw was not deposed, and I don't believe he gave an affidavit either. So basically, a lot of what the appellees think that Shaw thought is pure speculation. There's no evidence that Shaw disbelieved the threat. I mean, there's just no evidence of that. Deal with your own problems means one meaning could be, I don't care, whatever happens, happens, you keep asking for transfers, I'm done with it. The other point about that statement is, I think it's a statement to Zirko that, you've done this too many times, you've complained too many times, whatever, you're not getting any more transfers. And the fact that he had already been with this inmate for 9 months means that I think the inference that he's a transfer hound or applying for transfers every 2 seconds is probably not correct. So for all of those reasons, this is a case which should go to the jury. There'll be arguments to the jury about whether action could have prevented this or whether action should have been taken. But those are jury questions. Those are weighing subjective and objective together. Shaw may testify at trial to a whole different series of events, and that's his right. But at this point, it should go to trial. It should go to jury. And if no further questions, thank you. Thank you.
Thank you. Thank you very much, Mr. Richards, Ms. Citron. The case will be taken under advisement, and we will be in recess until tomorrow morning at 9:30. Thank you.